Hey guys, welcome back to True Crime with Shannon, where I cover missing persons, unsolved cases, crime news, and more. Well, I wanted to briefly go over the second hearing that was more of a motion hearing yesterday to schedule the actual hearing, it seems like, the actual motions, for the gag order and the cameras in the courtroom involving the Bryan Kohberger trial and getting justice for these four out of Idaho. And, I thought about this all night long, and I listened to some experts through YouTube, through the news, and all that. And my opinion, personally, is stayed pretty much the same, but on the gag order, I'm kind of starting to relent on why that may be a bad thing to release the gag order. But let's discuss that. I'm going to play a bit of the hearing. It went on for quite some time, and the judge was just talking about logistics mostly with the attorneys and what have you. And yes, Bryan Kohberger, the defendant, was present for this. As well as, of course, his attorney and the state attorney's district attorney's office. Excuse me. So let's play a bit of that, and I wanted to go over the KTVB article on it, and also go over a bit of the First Amendment and the Sixth Amendment, because I looked it up, and let's chat about that. So let's check out a bit of the hearing on the gag order.
Back on the record, State versus Bryan Kohberger, CR 29222805. I was explaining how the order and the scheduling conference might go, at least my plan. And so I'm going to start with you, Mr. Carone. Your clients have the motion to vacate the amended non-dissemination order filed May 1. Also the motion to intervene filed May 1, same date. And now this case is in my hands, so I need to set a hearing. And I'm wondering how far out. I'd like to get some briefs, and this is a message to everybody before the hearing, including I want to hear arguments about whether or not there should be cameras in the courtroom in a high-profile case like this one. So, Mr. Carone, what looks good for you? And let me throw out, knowing that a lot of you were prepared to be here the week of June 26th, that might make sense. But I'll hear from you, Mr. Carone.
Yes, Your Honor. So with our motion to vacate, motion to intervene, we've briefed the merits issues there. I think as the court's aware, we also briefed those issues before the Idaho Supreme Court, so I would think we could be ready to move pretty quickly. We have not briefed the issue about video cameras in the courtroom, so if that's something that you'd like the media coalition to weigh in on as well, we would need to submit a separate brief on that, but we can do that in the week of the 26th. The 26th itself, I'm not available, but the rest of the week would work.
Excellent. And I'll tell you, the reason that I'm bringing up cameras in the courtroom is because if I address that issue, and I haven't let you all know that that might be an issue, then I'm going to get a lot of grief for not allowing you to brief that issue. So that's why I'm giving you an advance notice on that. How do you feel about the afternoon of June 27? Given what's happening just quite recently, we might want to do that in person. I'm willing to do it remotely, but then we have to, there are a lot of different interests and different people who want to weigh in on that, so it might be better to be in person. But Does that work for you? Say starting at 1:30, June 27, Mr. Carone?
Yes, Your Honor, that works for me. And Ms. Olson and myself can both come in person. We would have been there today in person, but we found out about the in-person option on Friday, so I apologize for using Zoom today, but we can certainly be there in person. If the court's anticipating hearing from witnesses that day to hold an evidentiary hearing, there may be some witnesses that would want to appear via Zoom if that's okay with the court, but I'm not sure if that's even something you're contemplating. I'm just flagging it in case you are.
Well, let me put it this way: it's your motion and others' motions, and one of the complaints that I've seen in the briefing is that there's no evidence in the case supporting any of it. You know, we're all kind of moving forward on supposition, I guess. And some of it is obvious, but I think that would be wise. I suppose you could just file declarations, and that's what's been how that's been going. I might, if we're going to have a lot of testimony, I might want to move this back to 10 a.m. just to make sure that we have enough time to get things finished that day. Would that work for you?
Sure. So our position on the evidentiary issue is your summary was correct that we don't believe that there is an adequate factual record at this point, given that it is our motion and it's based on the record that existed when the order was issued. Procedurally, I'm not really sure there is an opportunity for additional evidence to be put forth. I only brought that up because I saw in Mr. Kohberger's opposition to our motion for reconsideration that there was a mention of an expert witness. If that evidence was going to come forward or other evidence, we of course would want the opportunity to cross-examine that individual or whatever individuals might be testifying. But, you know, as things currently stand for the record as it exists and the evidence that the Media Coalition intends to put forward, we included a declaration with our motion. I'm not sure there's really need for us to put on additional evidence, but if that's something the court was going to hear from the state or Mr. Kohberger, then I just wanted to bring that to the court's attention.
Thank you, Mr. Corona. Of course, you'd be have the opportunity to cross-examine any witness. All right. Well, we'll stay at 1:30 then. So now, Mr. Gray. So I'm thinking that maybe we should keep these things together and do them the same day if that works for you and your clients.
Well, Your Honor, I see the issue very clearly different from the AP's motion versus my motion. I think their motion is more of a getting rid of the non-dissemination order, the gag order. My motion is a motion to amend and or clarify some of the issues in the gag order. They have a lot of constitutional different issues that we have. I have some issues that I think are very separate. So I would request a hearing on my own much sooner. I think the court's aware I filed this motion in February on this case, and there was a massive delay based on the fact that previous Judge Marshall, was waiting for the Supreme Court to get some clarification regarding the AP's motion that she filed with the Supreme Court. So I'm ready to go when the court's ready to go, but I think our issues are very, very different than that of the AP's motion on this case. So I would request a hearing much sooner I can do it by the end of this week.
All right. Well, and I recognize this was all pretty short notice for everybody, and I don't know if let me go to Mr. Rudley and then Mr. Logsdon, because they're going to weigh in on that motion as well, I'm assuming. I'm thinking about maybe June 9th would be the soonest I could do this, but let me go to you, Mr. Logsdon.
Obviously, if the court were to agree with some of the things that he says and winds up amending the order, that could change everything for everybody else. So to some extent, I think it actually is probably better to do them all at the same time so the court isn't in piecemeal changing what we're all arguing about. But I would be ready for the 9th if the court chose to do it that way.
No judge likes to do things piecemeal. But I also understand that Mr. Gray and his clients have been waiting for a long time now. It's not anybody's fault. It's just how that came down because the Associated Press et al. Went straight to the Supreme Court in February, early February, and that would trigger a delay, which it did, and it was important, I think, for Judge Marshall to get the direction from the Idaho Supreme Court before we start, chipping away at each order. I don't know if would you be. I mean, I'm okay setting it for June 9th, Mr. Gray, but you may have some testimony happening. You may want to wait until you hear what everybody else is saying. It's likely that there's going to be some adjustments, you might say, or clarifying in the order. Partly in my reading of the Supreme Court's decision, maybe I'm reading too much into it, but there were some hints maybe of what the trial court might want to consider. Okay, go ahead, Mr. Gray.
I was going to say that since this is your gag order now, this non-dissemination order, Your Honor, and in reading my motion, if the court does want to consider making some of the modifications that might have been suggested in my motion, my motion may end up being moot. I think some of my modifications and or clarifications to the non-dissemination order are fairly minor, but allows, and I think the Supreme Court did give some guidance, which I think added weight to my arguments and my motion. So it's not above the court to take a look at my motion as well as any other motions that have been submitted to the court and modify the non-dissemination order, allowing for some of the issues that I've discussed in my motion, and then you would only have the AP who are attacking, I think, the gag order as a whole, the non-dissemination order as a whole. I'm just addressing a couple of clarifications and amendments that would allow myself as an attorney to speak on behalf of my clients that regarding the non-dissemination order, and I think it's your order now, so you're more than apt to be able to go and make those changes, and then we wouldn't have an issue with the non-dissemination order at all. So I don't think that's so. Obviously, the 9th, I'd like to keep the 9th because my issues are very small and narrow regarding that non-dissemination order. But if you were to make changes to those ahead of time that I was able to review and it was acceptable, I would withdraw my motion, Your Honor.
Okay. Thank you, Mr. Gray.
Thank you.
Well, it would be highly unlikely for me to change the order before I hear from counsel, because I don't want to, third, fourth, fifth, sixth. I only want to do this once, and I'm happy to set it for June 9th, maybe 10:30. Does that work for you?
That does, Your Honor.
Okay. Does that work for you, Mr. Rudley?
Yes, Your Honor, it does.
Okay. Mr. Logston?
We'll make it work, Judge.
Okay. Let's do that in person. Okay. So now we have the June 9th at 10:30. We also have the Associated Press et al. On June 27th at 1:30. I assume that works for you, Mr. Rudley?
It does, Your Honor.
Okay.
Yes, sir.
Okay, excellent.
All right, so the judge talked about the key phrase that he was using was irreparable harm. And that has to do with the media that's affecting a fair trial for Bryan Kohberger. And granted, most of us are like, well, who cares if he did it? But we have to step back on that for a second and realize that every single person in the United States of America, in this country, you are innocent until proven guilty in a court of law. So as much as we may believe that he allegedly, at this point, we have to say allegedly, did this horrific crime. He burglarized this home and took the lives of these 4 college kids. We don't know that for sure. The evidence, if it's there, it's going to prove that, during the trial, which may or may not take place in October. So they go over, obviously, the whole entire court proceedings from yesterday in this article. So I'm going to kind of sift through it, and we'll get to the gist of some of the stuff here. Moscow, Idaho. A Latah County judge issued a stark warning following Bryan Kohberger's arraignment that the media has done, quote, irreparable harm, unquote, to Kohberger's case and could affect his right to a fair trial. Judge John C. Judge, and I don't know, I'm never going to get over how much I kind of like that name, told the court that the media and attorneys alike have a larger responsibility to the Sixth Amendment, the right to a speedy trial by an impartial jury. After Kohberger, the man accused of killing 4 University of Idaho students, stood silent on Monday during his plea and a not guilty plea was entered on his behalf, a hearing was held to decide when to hear arguments on a non-dissemination order within the case. And I have a previous video just on his plea portion, so I wanted to separate that. Now, known as a gag order, it forces those involved in the investigation or with knowledge of any evidence to abstain from commenting about the case. On February 6th, the Associated Press, which we all know as the AP, and other local Idaho media outlets filed a motion to nullify the gag order in the case, citing First Amendment violations. A scheduling conference for arguments on this motion was held at 11 a.m. in front of the judge. Ultimately, he decided to hear the AP's arguments on the matter on June 9th at 1:30 p.m. That will include discussions on whether or not to have cameras in the courtroom during future proceedings, but not without some words for the AP's attorney and the media sitting, watching, and writing in the courtroom. The judge had to say, irreparable harm goes both ways. Arguing that the First Amendment is absolute is also troubling. The Associated Press needs to tone it down. Judge says that some of the coverage from certain media outlets is, quote, concerning. And I have to agree with him. We have some outlets, some media that are being very responsible in their journalism, and they are reporting, allegedly, or he's suspected. They're using the right terms and protecting the rights of this defendant. And then you have others that are going out and just slamming him to the wall and saying, well, he did it, and there's no way he didn't do it, and they're going on and on and on. And as much as we all may believe that Bryan Kohberger committed this crime, he has a right to a fair trial. Now, on that matter here, I wanted to read a bit. I pulled up some information about the Sixth Amendment before I continue to go through this article. The Sixth Amendment addresses important issues relating to criminal law. It grants several rights to those facing criminal charges, including the right to an attorney and the right to a trial by jury, which we already have, so we're on that one there. Basically, what the Sixth Amendment says is, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. What that means? Well, I'm going to include the link to this. This is a very informative piece, and again, it speaks in pretty basic language. So basically, you have that right to an attorney. You have the right to a speedy trial. So your rights are right to a speedy trial, right to a public trial, right to a trial by jury, right to an attorney, and notice and confrontation of witnesses. Now, the judge is concerned that he's not going to have these rights Bryan Kohberger, with releasing this gag order, this evidence is going to come out. You're going to have people automatically condemning this man, which has already been happening. You're going to be condemning Bryan Kohberger before the evidence is presented to a jury. And yeah, that's a question on any huge trial that has gotten as much media attention. So I have to agree with Judge on that one, that it is, the more you look at it, it's concerning with the fact that the media is not being necessarily all the time careful with their coverage. Again, so basically he's trying to tell them you guys are not always being fair to this man, and you're not reporting it with correct journalism. He didn't use that phrase, but that's what I get out of it. So I'm really hoping that we can come to a compromise, that the judge, that he's going to somehow allow, a compromise on this. What I'm really hoping is that, my opinion at this point is that, from the way I hear Mr. Judge speak, I think he's going to deny the gag order being lifted. Or if anything happens, it's going to be very bare as far as on the media portion of it, the AP and the media. And that to me seems, as much as I want to know and you want to know, it seems pretty fair to me to keep the integrity of the trial. And if too much gets out, it could affect a fair trial. And we don't want these families to have to go through this, more than once. But that said, I'm still hopeful that we're going to get cameras in the courtroom. To me, I believe that that's right. And that's where I kind of come off of saying, I have that journalistic kind of background. I wanted to be a journalist for many, many years. I studied it, and I have that same thing as the AP and whatnot. I want to be able to hear everything going on and see it presented. But we just saw Lori Vallow. They didn't allow cameras in there, and he's going to cite that. He kind of alluded to it, whereas you have too much focus on the defendant, every move they make, every expression. And I could tell you from looking at Facebook and hearing the media, every defendant is analyzed, every expression. I'm reading all sorts of stuff from, he looked scared yesterday. He actually looks like he might be taking this more seriously. And it's human nature, granted. But I honestly hope that they can come to a compromise on that. Maybe keep the gag order in place. Let the Gonzalez, they have another separate motion going on as well, because the family wants to be able to speak to the media. And I'm thinking that the judge may grant that to some degree. But to me, I'd rather have the gag order remain intact to keep this integrity of this trial, and then get those cameras in the courtroom. I know from hearing multiple defense attorneys today talking about cameras in the courtroom, most defense attorneys don't want cameras in the courtroom. They don't want live feeds. They don't. And I think it's more of a state wanting it, and even then, they are kind of iffy on it. So it's mostly the media and all of us who are glued to these trials, all of us true crime folks, and all of us wanting justice for these 4 college kids. So, I don't know. I think it's going to be a tough one. And I think that the bottom line is we want justice for these four beautiful people. And if keeping a gag order in place, as much as we all hate it, if that's what it takes, I'm going to have to say, all right, let's keep it in place. And it sucks. Yeah, that's the bottom line on it. And, again, as much as we all don't like when you have a defendant who is accused of a horrific murder or murders, we just had the Letitia Stouch trial. Of course, there was a lot more evidence going into that. But the bottom line is every defendant has a right to their fair trial. That's their Sixth Amendment right. And if the First Amendment is going to come clashing with that and cause potential appeals or having a case thrown out, it does start to get very, very difficult to kind of, keep those lines from blurring. So, yeah, I don't know. Yeah, I mean, like I said, I've changed my thoughts on it from researching, and watching the judge, 2 or 3 times, watching him talk yesterday, and I can tell you, he's already, if you listen to his tone, he's pretty anti releasing this gag order and pretty anti cameras in that courtroom. So, but we shall see. I think on June 9th is going to answer a lot more questions on that. But let me know what you think in the comments. Do you think that this gag order should be released? Do you think that we should know, a lot of more stuff? Do you think that we need to keep it in place to protect the integrity of the trial so that we can get justice for these 4 folks? And what do you think about the cameras in the courtroom? Let me know what you think. That's all I've got for this one. I've got some other videos I'm working on. I am still working on the whole CPS situation in Long Island, New York, coming out of the Thomas Valva trials for his father and his his potential step monster. So that is something I am still working through because there's a lot of information and we're pending a grand jury on that one. But so stay tuned if you are following my coverage on that. With that said, I hope you have a great rest of the day, and most of all, stay safe.